Lord, as your Lordship is aware, the underlying premise of the Commission's genealogy was that Botha should not have been appointed, Nelson should have been. And in our heads of argument, we've made extensive submissions as to why we say that underlying premise is also wrong and is fatally defective. But in the light of the subsequent error, what we say is a subsequent fatal error, the resolution of the decision of our convening, I don't propose to address that in our argument. It's set out in our heads, and we stand by what's set out in our heads. We say that the 1939 process too was fatally flawed for the reasons set out in our heads. That brings me then, my Lord, to the chapter 5 of part 5 of my submissions, which is the admission of the evidence of Dr. Claessens. And it's convenient, I submit, to deal with that now, because now one's seeing what the relevance, that the evidence is where it goes. And we submit that the evidence falls to be admitted for 10 reasons. The first reason is that it is placed before the court in a procedurally correct manner. There's no procedural defect, no procedural obstacle to the admission of the evidence. So there's no procedural problem. Secondly, we say that the evidence is relevant to the matter in issue in this case. It goes to the very heart of the matter, which is the content of AmaMpondo customary law, and we say that its relevance is self-evident. My submissions are based on those conclusions. Thirdly, we say that it is the very evidence which the Constitutional Court considered and debated in Sigcau 1. That evidence was placed before the court in Sigcau 1 by the Centre for Law and Society, of which Dr. Claessens was then a part, as you'll see from a CV. And it's dealt with in the authorities bundle. And the Lordship will see at the foot of page 118, there's paragraph 18. The court says the following: the Centre for Law and Society was admitted as a friend of the court. Its submissions were restricted to the approach that the Commission and the President should have adopted in the process of appointing a king under customary law. It contended that this entailed a recognition of this court's jurisprudence, emphasizing the living aspect of customary law, that historical rules or principles of customary law were often after-the-fact rationalizations of what was in its living aspect, pragmatic decisions based on what best served the community, and that this approach was not apparent in the Commission's in the President's and the Commission's approach. So it's the very point, which is the very evidence which is raised here. It was raised in the Constitutional Court. Your Lordship has been told in the affidavits that it was vigorously debated in the Constitutional Court. There was engagement on the issue. It wasn't suggested the evidence was inadmissible or irrelevant. In the end, the court didn't have to go there because the court decided the matter on the procedural ground. But we submit that it can't possibly be in the interest of justice to exclude it now in the review, which is the result of the decision of the Court of the Constitutional Court in Sigcau. And we make bold to say that, with the greatest respect, the Constitutional Court would be very surprised when now that it's placed before the court in its proper context, in the proper process. Fourthly, the fourth reason why we say it should be admitted is that the Constitutional Court also considered evidence to this effect in the Shilabana case. Can I take the Lordship to page 320 of the authorities report? Paragraph 35, the rural women, that's the amicus, emphasized that customary law is a flexible living system. This was a case about the appointment of a woman as the constable. The rural women emphasized that customary law is a flexible living system of law which develops over time to meet the changing needs of the community. It's not rigidly rule-based, and courts must exercise caution in ascertaining the content of customary law from the written records of apartheid-era administrators, legislators, and courts. Accordingly, the choice of Ms. Shalabana as Posse should not be viewed as a development of customary law is necessarily flexible. They furthermore argue that the customary law of succession has always been complex, with competing rules that may become more or less important at a given time depending on the needs of the community, in other words, the facts of the ground. The rural community women claim that the inheritance of the chieftainship was not automatic and prescribed. It involved a process and was dependent upon the support of the councillors in the army. whose backing was in turn influenced by the power and popularity of the individual competitors for office. So that was the issue in that case, one of the issues in that case. And in paragraph 65 at page 322, this is what the court said. The evidence and arguments presented by the rural women are attractive and persuasive. However, they are not before the High Court of the ECA, nor was the evidence before this court on this point clear. The court in the end didn't go there. But it's now, the court said the evidence was attractive and persuasive. That's the evidence which is placed before the court. The fifth reason why we say the evidence should be admitted is that the expertise of Dr. Claessens has been previously accepted by the Constitutional Court on 2 occasions. In the bundle of the authorities at page 281, the Lordship will go there, the Lordship will find the Rangude case in the Constitutional Court. And this is what the Lordship will then go to page 294, paragraph 27. Justice Goliath for the court says in Gomede, Moseneka DCJ, relying on the expert evidence of Professor Clark, said the following, and he goes on. Then paragraph 28 over the page 295, she says, later in that judgment, that's in the Gomede judgment, Moseneka DCJ also relied on the evidence of Dr. Claessens, which had been compiled by reviewing authorities and ethnographic material to demonstrate the manner in which property rights held by African people were distorted in favor of men under apartheid. And then if you turn to the footnote at the foot of the page, footnote 31, this is what they say of her. They say Dr. Anita Claessens is the director of the Land and Accountability Research Center at the University of Cape Town. Her overarching research focus is on the nature and content of customary law in the South African Constitutional Dispensation. That's what she's giving evidence. Yeah. So her expertise has previously been relied upon by the court. Sixthly, the sixth reason is that the methodology used by Dr. Claessens has been accepted by the Constitutional Court. And that also appears from paragraph 28 in our ruling. Because the evidence, as they say, as Justice Goliath says, is the evidence had been compiled by reviewing authorities and ethnographic material. Now, that's exactly what Dr. Claessens has done in this case. She's looked at the authorities and the experts. She said, this is what they show, this is what their opinions are, and this is why. So the methodology has been endorsed. I seem to have missed out 7th and 8th. So they are only 8th, not only 10. The 8th point is that the persons on whom Dr. Claessens relies are people of very great eminence. I've shown that to your Lordship. And none of the factual material on which she relies, their opinions and their historic findings, are placed in dispute. And then finally, the central thesis, which is the flexibility of the rules and the central role of popular acceptance, has now belatedly been accepted by the Commission in its last affidavit. So we submit that for all of these reasons, the evidence, certainly the evidence which is material to these issues, the issues in this case, is actually not in dispute. So we submit that for all of these reasons, the evidence of Dr. Claessens must be admitted and accepted. The respondents complain in the heads of argument or in their supplementary affidavit that Dr. Claessens holds and expresses opinions. And that's what experts do. They give opinion evidence based on facts which they know and research which they've got. And then they then say her views weren't placed before the Commission. But that, with respect, is irrelevant. The Commission had the duty to investigate this matter. It's the body which has to do it. It had the core facts before it. The facts of the unanimous meeting, the facts of the election, the facts of 28 out of 25 senior judicial members. It was to them to investigate what is the content of African AmaMpondo customary law and apply it. And so this is not an appeal where we're limited to the record. This is a review. So for all of those reasons, we submit that the evidence of Dr. Claessens should be both admitted and then accepted. That brings me to the sixth part of my submissions were on, and that is the alleged delay in launching the review application. The respondents now say in their heads of argument, I'll give you a watch of the reference, but won't go there, in paragraphs 59 to 66 of the respondents' heads of argument. They say that there is an impermissible delay in launching the application. And we make three submissions. Firstly, we say it's wrong on the facts. The founding affidavit, page 13, paragraph 17, this is the opponent now from the donated from Lombekiso, says the following. It says, your Lordship will remember that the decision of the Commission was made in January or February 2010. He says, on the 28th of February 2010, the CEO of One Military Hospital, Pretoria, admitted as a patient, and made a message to me on behalf of the Premier of the Eastern Cape that I was required to attend a press conference on 29 July in Bishop. I requested my wife, the Queen of AmaMpondo, my daughter, and Nkosi, to attend the press conference on my behalf. They informed me that the Premier read the press statement JMS 2. The statement made a mention. Now that's the statement where the Commission announces, or where it's announced, to put it in neutral terms, that the Commission has found that Zanozuko should be the king, not He says at the press conference, one of the traditional leaders asked the Premier a question whether I had been deposed, as there had been no mention of what would happen to me. In response, the Premier said that she'd been mandated to read the statement, she didn't go beyond the statement. I respectfully submit that this conduct by the Commission in the first response was unfair and infringes my right to dignity. Since July, I'm not sure whether I'm still the King of AmaMpondo and whether I'm more salary at the end of this month. I'm not sure if the announcement made at that conference means that I've been deposed or removed as the King of AmaMpondo. Now, the clear meaning of all of that is that that was what we learned about the first time. It's a clear interest to be born from that. And the respondent, on the other hand, says, respondents say in the heads of argument that the Commission's findings were announced on the 21st of January, 6 months earlier, 6 months earlier. But there's no evidence for that. There's no authority, no reference to the record. There's no evidence that it was announced in January 2010. The clear inference of the evidence of Lombekiso is that he only discovered this in July 2010, when the press statement was released. And the application was launched on the 8th of November 2010, which is well within the 180 state departure, 180 days. The Lordship will be aware that the departure test is 180 days from the time when the decision was made or when you could reasonably have been aware of it. He was first made aware of it on the 25th of July 2010. Well within 180 days. It's launched well within 180 days. So we say that the allegation of delay in launching is unfounded on the facts. Secondly, we say it's an extraordinary thing to raise now because it's never been raised before. It wasn't raised before His Lordship was the Justice Secretary. First heard the review application. It wasn't raised before the Constitutional Court, which considered the review application and set aside Justice de Klerk's decision. It's never raised before, and it's never raised in the answering affidavit. It's never raised before. It's not raised in the supplementary answer. Supplementary affidavit in relation to the amendment. It's raised now, and one has to say it's raised as a measure of desperation because it's an attempt to stop the review. A belated attempt to stop the review, which was heard, which was decided, which was a matter in respect to which the Constitutional Court gave judgments and decided the dismissal of the review. And we said, it's the fact that it's not been raised is an indication enough that it's really without substance. We say this also thirdly, that if the point was a good one, then the Constitutional Court could never have set aside the High Court's dismissal of the review and said the review is still live. Because the review should have been dead by then because it was launched too late. And so the very fact that the Constitutional Court said the review is still live indicates that it's a point without substance, and it is, with regard to due respect, a last-ditch defense of desperation. which is the complaint that the applicants have not applied for condonation in what is said to be a mere delay in pursuing or prosecuting the review after the death of the individual. And we deal with this in our heads in paragraph, in page 67. Can I take the Lordship to our heads? So I'm going to just follow the heads of it. Paragraph 172, you say the submission that there's an impermissible failure to seek condonation means that the application must be dismissed. You say the submission is procedurally incorrect and substantially unsustainable. As to procedure, we say there's not been a reasonable delay in instituting our dealt with that. In paragraph 173, you say the Supreme Court of Appeal has recently confirmed that an inordinate or unreasonable delay in prosecuting an action, which is what's complained of here, may constitute an abusive process and warrant the dismissal of an action. And we then refer to what was said in the Customs case on the SCA is in the authorities bundle, page 228. Paragraph 12 on page 233, this is what the Supreme Court of Appeal said. After discussing the question of when an action should be dismissed, what the test is, what the criteria are, and so on, the court then says, paragraph 12, an approach that commends itself is that postulated by Salmon and J. in the English case of Allen versus Sir Alfred McAlpine and Sons, etc., before the appeal, where the following was stated at 561 to H, a defendant may apply to have an action dismissed for want of prosecution, either A, because of the plaintiff's failure to comply with the rules, or B, under the court's inherent jurisdiction. In order for the application to succeed, the defendant must show 1, an inordinate delay, 2, that the inordinate delay is inexcusable, and 3, that the defendants are likely to be seriously prejudiced. So what the court approved was the approach of the Court of Appeal in England, which says the defendant is the party that applies to have the proceedings stopped on the grounds of delay. And if there's any doubt about that, if your Lordship will then go to paragraph 21, the court then refers to what was said by Lord Diplock in his judgment in the same case. And at the top of page 238, this is what Lord Diplock said. Since the power to dismiss an action for want of prosecution is only exercisable from the application of the defendant, it's only dismissible. The power to dismiss an action for want of prosecution is only exercisable on the application of the defendant. His previous conduct is always relevant. So the Supreme Court of Appeal has approved the principle that if there's an allegation of impermissible delay in prosecuting the case, it's for the defendant to apply for struck out, and then the applicant applies. And that's our laws. The respondents say in their heads that, it's well known in our law that the plaintiff must deal with it, the applicant must deal with it, but they cite no authority. They say it's the established position in our law, but they don't explain where this established position is. The SCA has spoken on it. So we say it was for the applicant, for the respondent who alleged an undue delay of prejudice to bring an application and justify it. Secondly, we say that in any event, this is at page 68 of our case, we say that this argument is in any event substantively unsustainable on the facts. Section 34 of the Constitution entitles everyone to the resolution of disputes by the application of the law decided by a court of tribunal. Closing down limits that right. It won't be done lightly. We refer to the criteria set out in Qaukeni. We say, page 69, paragraph 179.1, the case is one of the very greatest public interest, affecting the lives of literally millions of rural people. This is no private dispute. It's a dispute which affects the nation. And we make the point that the applicants have never passively accepted or abided by the decision of the Commission or President Zuma. They and their predecessors have consistently and vigorously disputed this. And we say the delay is equally brought about by the state respondents. And the reason we say this is the following. The Lordship will remember that in Style 1, in 2013, the the Constitutional Court set aside the appointment of Zanozuko. A dispute then arose between the parties. The respondent said, that's the end of the matter, the President must now make a new appointment under the old Act, and the matter is now concluded. The applicants said, no, there now has to be consultation with the royal family before that decision can be made. And there was a dispute between them about that. As a consequence of that dispute, the respondents said, well, we're going to go to court to get clarity on this. They went to court, it went to the High Court, it went to the SCA, it went to the Constitutional Court. The Constitutional Court granted leave to appeal to the present applicants. It held that they had a reasonable prospect of success in their appeal. One of the justices ultimately found in favour of the applicants, and the rest of the justices found again, and the respondent's case therefore succeeded. But the case was held up for these 2 or 3 years, 3 or 4 years, because the parties were litigating about what the next step was. And the party which initiated the litigation very properly was the respondents. They said, we don't want to have any uncertainty about this, we'll go back to court to get clarity on it. They went back, they got clarity, they succeeded in their case, and within months thereafter, once the Constitutional Court had taken, as soon as the Constitutional Court ruled against the present applicants in Sigcau 2, they took steps to have the matter set out. So all they did, the period they were waiting, was the period while the litigation was proceeding, while it was being determined what was the proper next step. And so we say there's no basis for claiming that delay is inexcusable. The main cause of the delay is the steps which the respondents very properly took to obtain clarity as to the Commission claims prejudice, but I'll deal with it later. And I'll deal with but no argument of prejudice is made on behalf of Zanozuko. As far as Zanozuko is concerned, he was only appointed in November last year. So, this case was made. The application will be heard less than a year after his appointment. We say that the prejudice which will be suffered if the merits of the application are not considered as overwhelming. There will be no consideration of the legal validity of the appointment of a king, who now rule over millions of AmaMpondo. They will have no means to assert their living custody. We say that can't be in the interest of justice. That brings me finally to the question of remedy. We obviously submit that the decision of the Commission should be set aside for the reasons which I've argued previously, because it failed to consider relevant considerations, because it failed to carry out the duty imposed on the government. It's a classic Paja review of failure to consider the most relevant consideration, which was political acceptability or support. And so we say that the decision of the Commission has to be set aside. And we say, obviously, it follows from that, then the President's decision has to be set aside because it's based on the Commission's decision. The respondents' answer to that is to say the following. They say the original Commission no longer exists. They say, therefore, this matter, if your Lordship sets it aside, this matter can't be referred back to the Commission for reconsideration. Therefore, they say there's no effective remedy, and therefore they say the review application must fail. But with the greatest respect, that gets matters exactly upside down. What the Constitutional Court said in the All-Pay case is, first you decide the merits of the review, and then having decided the merits of the review, you then look to see what is the appropriate remedy. You don't say because there's no remedy, therefore the review can't succeed. That's exactly, with respect, exactly upside down. Your Lordship will be aware that under Paja, if your Lordship grants the review, your Lordship has the power, has to decide what is the just and equitable remedy. That's the phrase used in Paja, also in section 172 of the Constitution. So, if your Lordship decides the merits in favour of the present applicants, then your Lordship has to decide what is the just and equitable remedy. We say that there are two possibilities. The first possibility is to say, well, there is a new Commission under the statute. It is the successor to the old Commission. It must exercise the powers which it had in this case. It steps into the shoes of its predecessor. That's, of course, what usually happens, or quite often happens in the review. The decision is reviewed, By the time a decision is made, there's a new minister or a new board, and the identity of the decision maker has changed, but the entity has not changed. And
well, in Masindi, in the matter of Masindi versus Brown, the court had to deal with that issue. And he found that even the time, the period of office of the second commission has expired in 2016, December 2016. Because if you look at the framework act, the commission had 5 years, the original one had 5 years. Their term of office expired in January 2010. And shortly before then, the amendment was introduced to establish the new commission, which is a successor to that one, with reduced powers. But they also had a time frame within which to act. Now, that has expired. I was actively involved in that case. That has expired. And it's a conundrum that we all face with. If both commissions can no longer be reconstituted in terms of the act, the question is what then?
Well, then let me move on to that. I submit that the solution then is to see what is the just and equitable remedy. You can't just fold your hands and say, well, yes, nothing happens. And we say in those cases, in that case, the just and equitable remedy would be for the default position to apply. Your Lordship will recall that the default position or the usual position is that the royal family is in charge, takes responsibility for identifying the successor. Does that through consultation, through rules, for the rest of it. But the royal family is the usual body here. What the Act created was a transition period during which the Commission itself would do that, the first part of it. And the Commission took over that function. Now the Commission is no longer there to do it. We submit that the only solution then is that it reverts to the default position, that the royal family must do what it always does in terms of customary law and make the appointment. And that would be the appropriate just and equitable remedy, because the transitional body which stepped into their shoes has gone. And so the royal family can then go through the customary processes. It can nominate the king, send that nomination to the president in accordance with the procedures set out in the Act, and the president can appoint him.
Under those circumstances, it would be procedurally and critically that the court will then have to order the president to refer the letter
to the royal family.
Yes. And the royal family will then make that decision, whichever way, and then if they appoint a person, then it's up to the president to recognize. That's what seems to be the procedural part.
Yes.
I'm trying to find what you're saying. I'm trying to locate it within the practicalities.
Yes.
What should be done. And I'm not saying that's how it's going to be.
No, I appreciate it.
Yes.
That seems to be the only practical way of doing it, because nobody else can step in and make the decision. If the Commission is gone, nobody else can be given the power to make the decision, but a decision must be made. And the appropriate body is the royal family under the Act, following the procedures.
Constitute the royal family.
There's no
Just a matter of interest.
I don't know that well, but it's known to the people.
The whole people of the community.
Well, there's this.
Because that would depart from the definition of royal family.
Yes. Your Lordship doesn't have to struggle with that issue right now, unfortunately.
Yes.
Not a matter which your Lordship has to do.
You see, this matter has been in and out of court so many times that one would imagine this is an opportunity to try and bring an end to these proceedings. So I'm trying to, that's why I'm engaging you on this, because I'm trying to look at what possible remedies would come out of this in the event I would in favor of the applicant.
Yes,
yes.
I appreciate that. We submit that the most appropriate remedy, and actually the only remedy one can imagine, is that it falls back to the royal family in terms of the Act. Because now there's no commission to Then learned friends that are, then the question does of course arise as to what's to happen in the meantime. That's a problem which is more apparent than real, because after Sigcau won, when Zanozuko was removed, the appointment of Brother Zanozuko was set aside, the first applicant, the Queen, stepped in and acted, and she carried out those functions for a period of years until Zanozuko was reappointed. There was no difficulty in that regard. And so what can easily be done is that the Queen can be appointed again to act until such time as the successor is determined in accordance with custom and law, and we submit by vote. That would be best done by the royal family. The Queen is the second applicant, not the first applicant. She's the second applicant. She could step in again, as she stepped in for several years in very recent history. No. That's our subject. And this is anything else I'm sure of interest to know.
Yes, I noticed you buy the cost.
And we ask for costs. And this is a cheap one, only one cost. We ask for costs.
I would imagine this would be the first of another long road, because the issues here are very complex.
Well, it may
We're
be.
going to have Sigcau 3 now. But not so.
Well, my file in my chambers marks the papers in this case as Sigcau 3.
That's how it's going to.
And this may not be the end of Sigcau.
That's how it's going to transform. Thank you, Mr. Budlender.
Thank you.